And Mr. Bloom wished to be knocked out.
Not true.
Well,
I never said that.
Mr. Bloom, hold on. I'm explaining what was indicated to me.
It's not true.
Mr. Bloom, I'm saying what was said to me.
Yes, Your Honor.
I'm just not in a position to be able to do that. I can't.
You have the power, Judge. We just, Judge Simpson, so we brought it to your attention.
I have the power to do a lot of things. And then some of that power I use and some of it I don't. For close case of the people versus Jeffrey Bloom.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Good afternoon, Your Honor. Sam Bernstein on behalf of Mr. Bloom, who is present with me here.
All right. And just so that we're clear, I did receive a competency report, but I think we've already dealt with that. Or have we not?
We did, Your Honor. I thought we stipulated to.
I thought we did too. Okay, that's fine. All right, we're here for your motion.
Thank you, Your Honor. Filed a motion to compel discovery. I'm just trying to really get the case on track. Set for trial, but there's some things outstanding. Importantly, reviewing the police report, it states that on June 1st, 2023, Detective Soring was assigned a jail assault incident by Detective Lieutenant Teets. The incident report reportedly consisted of inmate Jeffrey Bloom assaulting jail medical staff. I received a copy of the jail reports from correctional officers Navin, Gillette, Westhoff, Tweedale, Grieg, and a written statement by LPN Rocky Isley, all of which have been attached to this report. And then the report goes on to provide a summary of the victim statement. That statement was never attached to the report in discovery, Your Honor. I do note that there was a response by the prosecution, which states that the prosecution received additional correspondence. Fast forward. Additionally, there was not a previous written statement by LPN Rocky Isley. Sergeant M. Grigg indicated that they spoke with LPN Isley, and he will provide Sergeant Gregg with a written statement about the incident, which will be forwarded. It seems like in the report, it's pretty clear that there was a written statement initially provided to Detective Soring, and that is what the main focus of my motion to compel is, Your Honor. I'm unable to move forward with the case until I've received that.
Well, have you spoken to either the LPN or?
Have I spoken with the LPN?
Yes.
No, Your Honor.
To see whether or not there was a written statement that she or he prepared?
I have not spoken with the LPN, Your Honor. In reading the report, it seems like there definitely was, because Detective Soring says that it was reviewed in preparation of this police report.
Okay. Go ahead.
And then just one more. Before I move on, Ms. Barroso did provide some of the requests that I had made to her originally. I know we had spoken about it a couple of pre-trials. She did provide those 5 jail reports from the correctional officers, so we do appreciate that. There was one other item that was the subject of that motion, Your Honor. It was body cam footage by Sergeant Gregg. It says that was reviewed in preparation of this police report. It seems like that body cam footage might be of directly after the incident, but given that it's part of the police report, and I think it might be part of an expected trial, it would definitely be appropriate for me to review that. It's kind of in the res gesta of it, but importantly, I anticipate that there could be testimony about whatever the body cam shows. And I guess I just don't know what it shows. It might show stuff relevant that I might need in preparation of the case, Your Honor.
All right. People's response.
Yes, Your Honor. I believe that I indicated in the response that I had made a request for the necessary items that Mr. Bernstein had requested on numerous indications. I believe I outlined exactly when I made those requests. I have received a written statement from the victim in this case. I apologize if I have not personally provided that to Mr. Bernstein. It was added to a discovery packet upon receiving it. I don't know if that has been released. I do know that our office had a security breach and all of the passwords got reset. So all discovered, and then
that was countywide.
Correct, but the discovery email in our office had locked out all of the legal assistance, so no discovery has been sent for a little bit of time here.
Got it.
So I'm not sure if the statement from the victim in this case was caught up in that lag. They did get access late last night, so they are having a little bit of an influx right now and catching up. That also is going to affect discovery at KCC's tomorrow, just so you're aware.
Thanks.
Happy Thursday.
With that, I do have in my email now a copy of that statement from the victim. I can email that to Mr. Bernstein personally if he would like to have that copy. I also received confirmation from Officer Gray that there is no body cam from Officer Gray. So there is no more body cam in that regard to be provided.
Okay. So the written report you have, and that can be forwarded to council.
Correct. For the record, though, I do want to note that that was not, it was explicitly stated to me that there was not originally a written statement provided by the victim. The officers went back to the victim and he then provided a written statement upon request, and that is what I have a copy of.
Okay, so initially, where it may indicate that there was a statement that was reviewed, that statement does not exist, what you said in the beginning.
It
Right.
is not a written statement.
Not a written, got it. And so then upon the request, a written statement was, okay, all right.
So there was no written statement back on June 1st that Detective Soring reviewed then?
The information that I have is that there was no original written statement provided by the victim, and a written statement was only provided upon your request.
Okay, thank you.
Okay.
You're on. Yeah.
And then
Wait till we're all
in
done.
terms of the body cam footage, that body cam footage does not exist.
That is correct.
Okay, and in any event, that's not body cam footage that is after the incident in any respect, right?
My understanding from Officer Gregg is that they were not present for the actual incident, so it would not have been any indication on the actual events itself.
It might have had, as Mr. Bernstein indicates, there might be something there, but we don't know if it were there, what it is. Okay, all right. Mr. Bernstein, anything else?
Well, I guess, I mean, it does seem in the report that there was a written statement that was reviewed, but I am hearing a representation that is not the case, and that there's a new one, and that there's a representation that there is no body cam footage. So given that, I think that kind of resolves, based on those representations, resolves the subject of the motion. So
Correct.
we can move forward.
The motion for discovery.
Yeah, and I trust Ms. Barroso will send that to me today. So
Okay.
I will review that with Mr. Bloom and see what's there for Mr. Isley. So, moving forward, I do want to get this on track towards trial. I don't know if there's going to be, I guess, part of the trial that might involve what would have been on that body cam. I may have to be filing an additional motion about that, but I was hoping to see the body cam footage first before we got there. Could the court tell me when the next final settlement conference dates are, what we're looking at?
Next final settlement conference dates are in April 5th. Is the final settlement conference date with jury selection the 8th.
Okay. I'm definitely gonna have a trial on the 8th, so I don't know, it's gonna be a tough one, but perhaps we could start getting this on track towards a conclusion, Your Honor. And
Well, I'm ready. I'm always on track, so I'm usually waiting for you guys.
we're agreeable now, it's gonna be going.
Okay. So, but you want to review that and go through Mr. Bloom and,
Yeah, I mean, obviously, I think maybe another pretrial day before then is just fine.
all right,
Could
that's fine.
accommodate next week or the week after.
Well, I have the 20th.
20th is fine, Your Honor. Thank you. We can just set the
So-
20th for now.
I'll set pretrial for March 20th, 2024 at 9 a.m. or as your Zoom invite indicates.
Yes. Thank you, Your Honor. I did file another motion.
Yes.
Mr. Bloom does bring up to me a lot that he's suffering from a lot of dental pain. It's a very nagging issue with him. It's something that, he's asked me to bring up to the court in the hopes that the court can bring him some relief. I know that I don't know how much the court's hands are tied on that kind of thing. But, as he is asking me to bring that up to the court, I did want to bring that to the attention. He's suffering from a lot of pain with his teeth and hoping for some, additional dental care.
Any response from the people?
Yes, Your Honor. I do not believe that this is the appropriate venue for this type of action. I believe that this is a 1983 claim and remedy, which would make it civil. At this point,
Certainly not inviting that, but go ahead.
at this point, I don't think that it's
Yes,
within
we
the
are.
court's jurisdiction to take any action on this issue.
Well, and I don't. And I read it and I don't take any action on it. Mr. Bloom had brought it up prior to the filing of a motion. He had brought it up one of the times that he was here. I asked about it so the council knows before it was a subject of a motion, because it was more a complaint that Mr. Bloom had. But I just wanted to see what the deal was. And so that council's aware. My understanding is Mr. Bloom, that the jail or the sheriff's office, I've never known the sheriff's office not to provide proper medical care of any case that I've had before me to any inmate or anybody in their custody. So that's the first thing. Second thing is that then my understanding, and again, this is my understanding based upon my conversations, is that the dental care was offered to Mr. Bloom. That Mr. Bloom, there is a dispute, maybe, of the type of anesthesia that would be employed. One being basically a local in terms of either lidocaine or novocaine type of injection. And Mr. Bloom wished to be knocked out.
Not true.
Well,
I never said that.
Bloom, Mr. Bloom, hold on. I'm explaining what was indicated to me.
It's not true.
Mr. Bloom. I'm saying what was said to me.
Yes, Your Honor.
That it was then told to me that Mr. Bloom had either a religious objection or some objection to the injection. Now, having said that, whether that be true, whether it not be true, is absolutely irrelevant to me, because I would agree with the people that I don't have jurisdiction. And even to the extent that if I thought something was going on, I do not interfere with I know in some counties they do order the sheriff's office to do something. I do not do that. And I don't do that for a very good reason. I do not have a medical degree. I do not have a dental degree. So I cannot say what would, even if I wanted to, I couldn't say what would be the best course of action for Mr. Bloom. if it were an issue of Novocaine or lidocaine versus being knocked, there is no way for me to even resolve that. That has to go to medical professionals. It cannot go to me to make that decision. Even as to what type of procedure would be necessary, I can't even go there, and wouldn't even begin to try to order that. So the best way for me to do this is I'm going to deny, for the reasons that I've just stated on the record, I'm going to deny the defendant's motion to compel dental care. I'm just not in a position to be able to do that. I can't.
You have the power, Judge. We just, Judge Simpson, so we brought it to your attention.
I have the power to do a lot of things, and then some of that power I use and some of it I don't. To the extent I may have some power over this, I am declining to do that because I do not have the expertise nor the ability to be able to tell them what should happen.
Fair enough, Your Honor. We appreciate the court's consideration of reading the motions, and it seems like our motion to compel discovery is resolved for the moment, so I'll leave that be, and we'll be back on the 20th. We'll be back on the 20th.
Could I please state something for the record? Please.
Only if it's quick, Mr. Blue.
Oh, well, I'm going to try to be quick, Your Honor.
No, you need to be quick. Go ahead.
Well, I was denied even Tylenol 2 days in a row in excruciating pain. This hoax with Rocky Isley, this perpetration of hoax that's being I've been subjected to, has kept me in segregation since the incident. I have been deprived of all, even basic human necessities, Your Honor. Medical staff, Cindy DeVue, who runs medical staff. Okay, I'm going to leave all that out. What you got, they won't give me any records, Your Honor. They won't tell me why. They're saying it's a security issue why I'm being denied dental care, because I don't take injections. I want that in paper. I have got nothing in paper. They're saying they have given me things in paper. Your Honor, their kite system, well past kite system, is a 1-page, no copy, no paper trail kite. Okay, so I have no record of anything that they're doing, and they will just say, Mr. Bloom refused. Okay, Your Honor. Now, that's just one aspect. That's just dealing with the dental thing. I would just like to mention on the record that the Lagos versus Metro Government Division of Nashville, where officials deliberately mislead the courts with reckless disregard for the truth, there will be sanctions. Okay. Students of the court who make improper certifications face sanctions. Rule 26G3 is also a violation of federal law. Okay. The court shall have a great interest in addressing allegations that its judicial system has been subverted. I'd just like to put that on record because, Your Honor, like I said, I have been deprived of all, even basic human necessities, even by medical care, jail staff. I've been in segregation, long-term segregation, for saying that I'll leave it alone, Your Honor. Thank you.
Thank you.
Once again, Jeffrey Bloom walked into the courtroom determined to challenge the court's authority. Confident in his arguments, he tried to explain why the rules shouldn't apply to him. But Judge Simpson wasn't convinced for even a moment. As Bloom continued offering one excuse after another, the judge calmly reviewed the facts and firmly rejected every claim. The courtroom quickly shifted as it became clear that unsupported arguments would not change the outcome. Judge Simpson reminded everyone that the court relies on evidence, not opinions or repeated excuses. With each response, the judge reinforced the importance of accountability and respect for the legal process. By the end of the hearing, Jeffrey Bloom's attempt to challenge the court had completely fallen apart, leaving little doubt about the judge's final decision. What do you think about Judge Simpson's ruling? Let us know your thoughts in the comments, and don't forget to like, subscribe, and turn on notifications for more courtroom stories.